6 months after the funeral, 4 siblings sat in a courtroom, not as a family, as litigants, case number assigned, opposing counsel seated on either side of the aisle. People think the funeral is the hardest day. It isn't. The funeral is the last day they're still a family. What comes after, that's the second funeral. And that one has no service, no closure, just paperwork. This is not a story about greed. Greed is simple. This is a story about grief wearing the mask of a lawsuit, siblings who loved each other for 40 years becoming, within months, legal adversaries. I've watched siblings spend $120,000 in legal fees fighting over a house worth $300,000. When I ask them why, they never say money. They say, it's the principle. There is no principle. There's only a 40-year-old wound with a new deadline. 2/3 of American families with more than one heir will experience some degree of inheritance conflict. A third of those will end in permanent estrangement. Tonight, we go inside the mechanism, the law, the math, and the psychology of how families dissolve, one asset at a time. Every family that ends up in probate court believed, until the moment they didn't, that they were the exception. There's a concept we use called the family glue theory. As long as one parent is alive, sibling rivalry is suppressed, not resolved, suppressed. The parent functions as an inhibitor. Children, even at 60 years old, will regulate their behavior toward each other because a parent is still watching. The moment that second parent dies, the inhibitor is gone. What surfaces isn't new conflict. It's decades-old conflict that finally has no supervision. This is the core clinical insight. The fight over the estate is rarely about the estate. It's the reactivation of a sibling hierarchy that was set in childhood and never renegotiated. The 45-year-old executor fighting with his sister is not a 45-year-old man. In that room, psychologically, he's 9 years old again, and she's 12, and someone just got a bigger slice of cake. I tell young associates, read the will like a legal document, but read the family like a psychological file. The people who fight hardest are almost never the ones who need the money most. They're the ones who felt least chosen. This is the myth that must die first, that a good family, educated, affluent, close, is immune. Money does not create the fracture. Money simply removes the excuse to pretend the fracture was never there. Parents, trying to be fair, make a fatal drafting decision, nomming 2 or more children as co-executors with equal authority. Parents think, if I name them both, neither one feels favored. It's the single most common mistake I see, and it's a recipe for a frozen estate. Co-executors need joint signatures on almost everything: selling property, distributing funds, closing accounts. If they disagree on one signature, the whole estate stalls. I call it the fairness paradox. The more equal the power sharing looks on paper, the more likely the estate is to never actually settle. Under most state probate codes, co-executors must act unanimously unless the will explicitly grants majority rule authority, which most handwritten or template wills do not. One sibling's refusal to sign is functionally a veto. Estates have remained open for over a decade under this exact gridlock. I've had estates on my docket for 11 years, not because the assets were complicated, because 2 co-executors couldn't agree to sign the same piece of paper. No asset carries more emotional weight than the family home, and no asset is more likely to force a legal proceeding called a partition action. When siblings inherit real estate jointly and can't agree, one wants to sell, one wants to keep it, either party can file a partition action. The court doesn't ask who has more sentimental attachment. It has one job: divide the asset. If the house can't be physically divided, which it almost never can, the court orders a sale. It's called a partition by sale. Colloquially, we call it a fire sale because courts don't wait for the best market price. They wait for a buyer. The math is brutal. A court-ordered partition sale typically yields 10 to 30% below fair market value. Once you account for a compressed timeline, mandatory court-appointed referee fees, and legal costs split from the proceeds before either sibling sees a dollar. The sibling who wants to sell is usually not the greedy one. They may live 3 states away, have no income tied to the property, and taxes and upkeep are draining them monthly. The sibling who wants to keep it isn't sentimental in some soft sense. They're often trying to preserve the last physical proof that the parent existed. Neither position is irrational. That's what makes it unresolvable without a mediator. I've sat across from siblings crying in my courtroom, not because they lost money, but because a stranger with a gavel just ordered their childhood home sold to the highest bidder in 90 days. The third trap is the least visible and the most bitter. What happens when one sibling provided years of unpaid caregiving, and the will still divides everything equally? We call it the invisible caretaker tax. One sibling gave up income, moved states, sacrificed a marriage even to provide care for a declining parent. The other siblings visited on holidays. When the will splits the estate equally, the caretaking sibling doesn't just feel shortchanged financially, they feel erased. Their years of labor were never legally documented, so legally, they don't exist. Legally, in the majority of jurisdictions, informal caregiving by a family member creates no automatic claim on the estate, no lien, no priority, nothing, unless it was formalized through a caregiver agreement or contract while the parent was alive. Moral obligation and legal entitlement are 2 completely separate systems, and most families only discover this after it's too late to fix. This is where equal and fair diverge permanently. Equal is a math operation. Fair accounts for years of labor, lost wages, and foregone opportunity that a court has no mechanism to price, unless the parent priced it themselves, in writing, while alive. Now the deepest layer. Attorneys will tell you the same story from 100 different families. The biggest legal battle isn't over the house. It's over a $50 ceramic ewer, an old wristwatch, a set of mismatched dishes. I had 2 siblings spend $11,000 in legal fees fighting over their mother's watch, a watch worth maybe $400 at auction. When I finally asked why, the sister said, "Because Mom gave it to her in 1985, and she never gave me anything like that." That's the whole case. That's the entire $11,000. Objects like that function as physical evidence in an emotional trial that's been running since childhood. Who did Mom love more? The item itself is almost irrelevant. What's being litigated is decades of perceived favoritism, finally given a courtroom and a docket number. We call this score settling, using the tangible, divisible estate to resolve an intangible, undivided grievance. This is the unspoken truth at the center of every inheritance conflict. The estate is the final report card. Every dollar, every object, every line in the will gets read, consciously or not, as a final, unappealable verdict on how much a parent loved each child. A parent cannot apologize from the grave. They cannot clarify, "I left you the piano because you're the only one who plays, not because I loved you less." The will is silent. Grief fills that silence with the worst possible interpretation. I tell clients, you are not fighting for the ewer. You are fighting for proof that you mattered. But a judge cannot award you that. A judge can only award you the ewer. If the disease is psychological, the prevention has to be structural. Attorneys agree. A simple will is no longer sufficient protection for a family with more than one heir and any meaningful asset. The first fix is procedural. Understand per stirps versus per capita distribution before you draft anything. Per stirps means if a child predeceases the parent, that child's share passes down to their own children, the branch inherits. Per capita means the estate is divided equally among whoever is alive at that generational level, and a deceased child's branch gets nothing extra. Families who don't specify this in the will are often shocked, post-mortem, to learn which one applied by default under their state's law. Second, the irrevocable trust with an independent trustee. Instead of nomming co-executor siblings, Parents can name a neutral third party, a bank trust department or professional fiduciary, to make binding decisions. No sibling has veto power over another. No sibling has to be the bad guy. An independent trustee removes the two most dangerous elements: the fairness paradox of shared executor power and the score-settling dynamic, because a stranger with no emotional history is the one signing the paperwork. Third, the no contest clause, a provision stating that any heir who legally challenges the will forfeits their inheritance entirely. It doesn't stop score settling, it raises the cost of it dramatically. A well-drafted no contest clause has ended more family lawsuits before they started than any judge ever will. But the most important intervention isn't legal. It's a single, uncomfortable conversation while the parent is still alive, explaining why the estate is divided the way it is, not leaving that explanation to a document that can't answer follow-up questions. And this is where the documentary ends, with the heaviest truth in the entire profession. At some point, every parent has to make a choice they don't realize they're making. You can optimize a plan to leave the largest possible inheritance, or you can optimize a plan to leave your children still speaking to each other in 10 years. Very often, those are not the same plan. I've never once seen a family destroyed by too little money. I've seen dozens destroyed by money left without a plan for what it would do to the people left holding it. The final estate you leave is never just financial. It is also the last thing you teach your children about each other and about you. You cannot control how your children grieve you. You can control whether you leave them a fortune or a family, rarely both.